Classified Crime is on the case of Sarah Boone, and today we're continuing the family court recap with mid-2023. If you haven't watched any of the other videos, I will link parts 1 through 4 here and also in the description. You can check those out. And if you have already checked those out, let's continue on with where we left off in part 4. We are picking back up with 2023, and we're going to begin with this motion for contempt written by Sarah on 4/7/2023. So as soon as the order granting the temporary relocation was complete on April 5th, 2 days later, she wrote a motion for contempt. All right, so this is Sarah's motion for contempt that she wrote on 4/7/23 and was filed on 4/11. Comes now. Sarah K. Boone, respondent, submits her motion for contempt for non-payment of alimony by Brian C. Boone, petitioner, and in which was court ordered by Judge Michael Deen to continue being paid to respondent in the last and only status hearing 9/19/22. Now let's pause and take a look at that. I don't know why she felt the need to say last and only, unless it's just a way of throwing shade that she wanted. She wrote twice about a hearing and then they only had one, but they can wrap it all up in one. Here are the court minutes from the hearing on September 19th, 2022. Hearing was held in person. Court ruling. The court will take no action on the notice for trial filed by Mr. Martel. Mr. Mendoza will provide an order to the court regarding any child support being vacated temporarily. This will be solely based on Ms. Boone's incarceration. Ms. Boone completed change of address form in open court. So it was a 30-minute court hearing. Since, during, and prior to respondent's incarceration, February 2020 to the present, how does that include prior to? Petitioner has completely withheld and or diminished incredibly the promised $1,000 monthly payments, stating repeatedly the respondent is not important and not priority. And he is solely responsible for caring for your son, so that should be his top priority. You're being solely cared for by the state, so he doesn't need to give you priority. This money owed to the respondent is overdue, ordered, and needed, being the only source of income to make any and all necessary purchases. Also, petitioner agreed to, signed, and made responsible for all said payments in the active court-filed dissolution of marriage of 2017, at which time no one was incarcerated, as Judge Jackson pointed out. Respondent is seeking all delinquent and arrears payments and all full current payments of $1,000 going forward to be made to the designated account of her choice. Now, she already said her account had closed, so how are you going to be able to open one from jail? That means someone else is going to be wrapped up in managing her money for her on the outside, and she's always telling us she has no one. Wherefore, Sarah K. Boone, respondent, respectfully requests this honorable court to please grant this motion for contempt, entering its order for alimony payments, delinquent and arrears, to begin immediately and without difficulty or confusion by Brian C. Boone, petitioner. Thank you, Sarah Boone. So she filed this motion for contempt a couple days, 2 days after the order from the hearing. Let's look at that order. So this is the order the judge would have filed on 4/5, granting the temporary relocation, and this is the one that listed all of the relocation factors. Now, I doubt that she would have received her copy of this yet because they would have mailed it out this 5th day of April, and she wrote the contempt order on the 7th, but she would have attended the hearing and know that it was granted. She then filed this on April 7th, and it was filed in the court docket on April 11th, and it's a second motion for contempt, and it's 4 pages. So I don't know why she felt the need to send 2 different motions, or if she's just saying this is regarding the motion for contempt, because she's writing a letter to the Honorable Judge Deen and Miss Coffey, who is his judicial assistant, and she addresses her directly in the letter as well. Honorable Dean, Miss Coffey, per your instructions in our last meeting, petitioned to relocate on 3/29/23 after stating to the court my still ongoing problem with former husband and him not paying alimony to me. You ordered to continue in the status hearing on 9/19/22. I am including my motion for contempt to obtain these payments and all missed, delinquent, or diminished. So right here, you're saying that he ordered in that hearing to continue to move it forward because they're waiting to see what happens with your criminal status. I am in the process of trying to figure everything out as it comes to me, and remember, pro se. So please bear with me and know I am doing all I can, figuring everything out, doing all I can to still utilize my rights, which seem to be tested and tried to be taken regularly since I do not have many resources, family, or an attorney. Former husband has in abundance, which was bluntly announced to everyone in the court by his attorney for whatever reason it was made to be necessary. I guess those without do without, but I'm still trying and always will. So she's probably referring to the financial affidavit he was required to submit. But that, I don't know, that didn't like show an abundance. I too am still in shock of the outcome for the petition to relocate and my minor son being advantageously taken 4 times the lawful amount, 50 miles to move away from me. 4 times the lawful amount? Okay, she's saying 4 times 50 miles. So she's saying he's moving 200 miles away, which is over the legal 50-mile limit without filing a relocation, which this is moot because she attended the hearing where they said that it was granted. So I don't know why she's bringing that up. Oh, because she's in shock that the judge ordered it. 50 miles to move away from me, the other parent. As far as I am aware, which is rare in this case, as no one includes me on anything. Well, you were at the hearing. They mailed you the order. That's including you. I still have my rights. Custody of my son. You don't have any custody. You might have like legal rights to know like his medical records and education, but you don't have any physical custody of your son. And am owed alimony. Nothing has been made permanent or signed to state otherwise legally or has been discussed again and needs to be, where in my previous numerous attempts I have tried, but told by you I'm doing it wrong. Nonetheless, you made known you do not read my letters, your JA does. For the 9/19/22 hearing, you addressed all my concerns in the letter I wrote to initiate and schedule it. Otherwise, how would you know to, if not by reading my letters? What am I doing differently this time? I thought my very legitimate ongoing concerns needing to be discussed and brought to your attention would be in the case management meeting that was then canceled. Why? Because I don't have an attorney. I have rights and am desperately wanting and trying to utilize them, but it seems only when I do it correctly I am able. Yes, there is a formal process in the court that you have to follow. How am I supposed to know what's correct or incorrect? It is only made correct, I guess, with money and an attorney. If so, mine will never be correct, but you most definitely still get my intentions for everything, especially to save my son from who? You? And be treated fairly. The judge is on the side of saving your son, just not the side you think. Also, what I have known prior to the petition to relocate hearing, it was really a trial. As I found out during, I know for sure I would have been better prepared. Well, we know you wouldn't have been better prepared and could represent myself even harder. But as usual, I was not included in that very important detail, except you got notices of all of this stuff. Had a chance, but in my opinion, your mind was already made up no matter what I said. Now you're accusing the judge of being unfair and biased. That's not going to go over well. Again, rarely am I included or made to feel significant enough to ever have anything of mine even mentioned. Why? Because I'm in jail. It's okay to take the abuse nonstop from former husband because I have nothing. This is unfair and wrong. I still matter and am important, especially to my son. Remember also, my circumstances are temporary and no one can tell the future, but apparently the trial before the trial happened already after being told by you it would not in the status hearing unless there will be yet another trial before the trial before the trial. What are you even saying? If so, please include me prior so I know what to expect and what I need to do properly to properly defend myself as best I can against former husband's ugliness, torture, and attorney. Wow. He's just filing legal modifications, motion to relocate. He's filing legal documents that will allow him to do what's in the best interest of the child. But you think that's torture. I am already being told and profusely laughed at repeatedly by him. They're never coming back. It's all going to be made permanent, and I can't do anything ever about any of it. You see Judge Deen / Henrietta, not even Miss Coffee here, just Henrietta. You've never met this lady. How even more terrible will I be made out by wanting to have my son close to me and is lawful after he's established friends, school activities, favorite places to eat. Then all of this is brought to you again to conclude and then be made to move again closer as included in the temporary relocation paperwork. Well, this is you trying to see the future. You're saying that at the end of your trial, they're going to be forced to move back, but you would have to properly, first of all, obtain and retain an attorney for longer than 40 days or be able to file proper motions to cause them to relocate and not just ramble on and on about why it's unfair to you. You would have to give legitimate reasons. And the judge wrote in the minutes that you didn't have any articulable reason not for them not to move in the hearing, as we saw in part 4. Or will it automatically be awarded to them like everything else and all their wishes come true permanently because I will have nothing and no one to help me figure any of it out when the time comes, if I even do it right in my hopeful attempts like I have been already? Like you have been already doing it right? That's what that seems to refer to me. Please tell me now so I know what to plan on, considering everyone seems to have a crystal ball but me. It's only fair and I should be included. From everything I have experienced so far with judges, courts, laws, etc., it seems true already. Everything will not be in my favor from the truly unjust way I have been treated and am still in this case. Is this how the justice system really works? Here's those quote unquotes. Maybe it's just me with nothing that it does. It only makes everything harder and more disappointing. If you're a no one with nothing like me, all you get is a hard time, innumerable hoops to figure out how to jump through, and laughed at, all for nothing. Judge Deen, you stated in the relocation hearing, also, it's a fresh start for son and former husband to move well beyond the 50-mile radius away from me. Why would you allow them to start before knowing anything of my outcome? Why? I guess I'll never get my fresh start from everything being made so impossible and arduous before anything has even happened. Well, no, something has happened. You took someone's life. And after, when and if it does, how much does it cost, please, to look into someone's crystal ball? Anyone's? Oh, wait, I have no money or attorney. There you go. That's how much it costs, hiring an attorney. And then you don't listen to them and they withdraw. And we're about to see that shortly coming up in her 2023 documents. Please include me. Think positive. Miss Henrietta. You should say Miss Coffee, not Miss Henrietta. If and when reading this, please take notes. What? Now you're telling her what to do and how to do her job? She just scanned this in. So it can be relayed properly and correctly, if at all, if it even matters. According to former husband, none of what I do will make any difference in anything, and I shouldn't be worrying about any of it. I'm going away for a very long time. My child will be an adult. I will probably never have to worry about it. Thank you both for your time and understanding. I matter. Sarah Boone. This was filed April 14th, 2023. It is an order setting a virtual hearing. It says this matter came on before the court, and the court, after reviewing the file and being otherwise informed in the premises, it is hereby ordered and adjudged as follows. This case is scheduled for a hearing on motion for contempt filed on 4/11/2023 on May 11th, 2023 at 9 a.m. via Zoom video. Time reserved 30 minutes. It gives information on the Zoom attachment, at least 72 hours. Prior to the scheduled hearing, all evidence must be provided to the opposing party and the court via electronic mail and filed with the clerk of court via e-portal or mailed to the clerk so that it arrives at least 72 hours prior to the hearing. And then it proceeds to give you the Zoom link signed by Judge Deen on the 13th day of April, 2023. And mailed to Sarah Boone and Joshua Martell. This was filed 4/18/2023. It is a motion to continue contempt hearing that they scheduled for May 11th. This was filed by Brian's attorney. Comes now the petitioner, Brian C. Boone, by and through his undersigned attorney, who hereby files this motion to continue contempt hearing scheduled for May 11th, 2023, and in support thereof states as follows. 1. On April 11th, 2023, the respondent filed a motion for contempt alleging that the petitioner is not paying his ongoing alimony obligation. 2. On April 14th, 2023, the court entered an order scheduling this motion for contempt for a hearing on May 11th, 2023. 3. The petitioner filed a petition to modify alimony on April 12th, 2022, and that petition is still pending as of the date of this motion. 4. Under the current law, the petitioner is entitled to have his petition to modify his support obligation heard and resolved prior to trial court's resolution on respondent's later filed motion for contempt for failure to pay support. And he cites a case law, Rosenblum v. Rosenblum, and he is stating under the current law, and he is a family law attorney. So he probably did his homework before filing this. 5. Therefore, the petitioner is requesting that this hearing be canceled and rescheduled either contemporaneously with or after the final hearing on modification. Wherefore, in view of the foregoing, the petitioner, Brian C. Boone, respectfully requests that this court enter and order canceling the hearing scheduled for May 11th, 2023, or any other relief it deems necessary. And there's a certificate of service that they mailed it to pro se respondent Sarah Boone at the Orange County Jail. On April 19th, we have a filing of the judge's order on the motion to continue the contempt hearing that they had scheduled for May 11th. This cause having come before the court on April 19th, 2023 on the petitioner's motion to continue contempt hearing scheduled for May 11th, filed April 18th, and having reviewed the file and being advised in the premises, it is ordered and adjudged as follows. The motion is granted. The hearing scheduled for May 11th, 2023 is canceled and will be rescheduled either contemporaneously with or after the final hearing on the modification, which they just had in August 2025. This court expressly retains jurisdiction of this cause for the purposes of enforcing, construing, interpreting, or modifying the terms of this order done and ordered in Chambers, Orlando, Orange County, Florida, 19th day of April 2023, and certificate of service to Joshua Martell and Sarah Boone. Now, she wrote this April 20th, 2023, and it was filed the 26th of April. She has probably not received the order that was mailed on the 19th. So let's take a look at what she said. Judge Michael Deen, Henrietta Coffey, Judicial Assistant. Hello, and thank you for granting a hearing for my motion for contempt, which he just canceled, scheduled via Zoom 5/11/23 at 9 a.m. I am in the process of gathering my necessary evidence as requested. Now, this is dated April 20th, 2023. She's in the process of gathering her evidence. The hearing didn't end up being until August 25th, 2025. So I just want that to sink in. It was like a year and a half of gathering evidence. Requested, but wanted to remind you, I am incarcerated. Oh, we know. And do not have the capability of using a computer to gather statements, calling about, or going to my bank. He knows that. And here we go with the blame game. And if I did, due to non-payment of ordered alimony by former husband, which is what this hearing is about, my bank account, which I've had for 30 years, is closed from having an ongoing, growing negative balance for an extended period of time. So the only sole reason your bank account should remain open should not be only determined by payments of alimony. That is also due to your incarceration, lack of holding a job, not working, not being eligible for unemployment or anything else because you are incarcerated. Because you are incarcerated because of your actions. Please know I'm doing all I possibly can from jail, except for self-reflection and accountability for my own actions. With what I am able to submit, I'm confident will suffice, showing not even one agreed order signed for $1,000 payment, along with all decreased amounts chosen by former husband to give sometimes. So this shows right here that he was giving, and the everyday payments deductions on my account. So this shows right here that he was giving decreased amounts chosen to give sometimes. So you're admitting he did give you something. And what you're able to submit when you can't get a statement, it's just your word against his. It's like hearsay, self-serving hearsay. Please note in the meantime, would alimony have been being paid? You didn't need that. Have been paid. I would not have to contact or be degraded by former husband every week to ask. You're not made to contact or ask. That is a choice you are making. He knows when commissary day is and has for over 3 years I've been here. Yeah, it doesn't mean that he's obligated to give you money every week. My bank account would not be closed 30 years. I would have essentials and needed items. Nobody cares. I would not be constantly lied to about phantom orders and made to ask for updates weekly. You are not made to ask weekly. You are not made to ask. I would have peace of mind. Nobody cares about being able to maintain blood sugar, glucose levels from having available and needed snacks. Needed snacks. There are medical ways to maintain blood sugar and glucose levels. I work in pharmacy. There are glucose tablets, chewable tablets. We have emergency glucose injections for low blood sugar. We have medications that help maintain your sugar. There are many varieties of diabetic medications. If an inmate is in need of a medication, they can't just deny something like blood sugar medication. They can't deny a diabetic medication like insulin. That's not something they can be like, well, you can't pay for it. I mean, they might add to your tab and your account be negative, whatever, and you can't have commissary, but you can have your blood sugar medication. So none of this is needed. But these sugary snacks are not the kind of thing you would need. And you can just have glucose tablets. I would not ever have a negative balance. Weren't you in the negative the night you asked Brian to send you over money to buy Woodbridge and you were getting your $1,000 a month payment? Other participants could purchase care packages for me without having to add money. So in the positive in my account and the only way to order. Nobody has to add money. Nobody has to buy you a care package. My medications could be paid for when processed. So I'm not sure how this works in the jail setting. I've never worked in a jail pharmacy, but it seems to me that they're processing them and charging you for them. They're just not paid at that time because you don't have money in your account. And then it's going negative, and then people have to add money to pay for your necessary things so they can order you a care package, which is not a necessity. It's a want, not a need. My temporary life of incarceration. One moment.
Ms. Boone, court sentences you to life in the Department of Corrections with credit time served. That
could be, to a small degree, simplified. Former husband would not have to deal with me continuously. I would not have to keep contacting the court. You don't have to keep contacting the court to take up the judge's time to order, again, former husband to continue paying. This is supposed to be a thank you letter for them scheduling the hearing, and instead she punished them. Former husband should not have made the decision to disregard the order to pay and made up his own rules along the way. This is contempt. Well, that's for the judge to decide. And all they asked you to do was to get your evidence together. If this letter is supposed to be evidence, I fail to see how. It's just your opinion. It was never acceptable for former husband to treat me in the very unacceptable way he has and is. Would I not be incarcerated, which makes no difference and is temporary?
Ms. Boone, court sentences you to life in the Department of Corrections with credit time served.
That is stated anywhere and agreed to in the dissolution of marriage agreement, which is before you were incarcerated. Former husband would have his license suspended, wages garnished, or be arrested and put in jail, where he'd get the idea real quick how it really works and understand everything I've been trying to explain to everyone for years now. Ma'am, if everyone you're trying to explain everything to is not quote unquote understanding you, it's because that's not how it really works and you're the delusional one. Okay. It does make a difference. Obviously, you're stating right here it makes a difference, because would you not be incarcerated, you would be able to impose these consequences for his actions. But since you are incarcerated, you are not able to. So it does make a difference. It doesn't matter that it's temporary. This is your temporary situation, whether you want to accept it or not. And it's really not temporary, but you don't know that yet. With that being said, my main and most important reason for this letter is to annoy everyone. Is to please request a copy of my marriage dissolution agreement. So asking the court to give you copies that they are not obligated to provide you with to properly prepare for this hearing that has been canceled. I refuse to be blindsided as I was for the last petition to relocate. I've asked former husband many times, as well as you, Judge Deen, verbally and in writing, with no success. That is because the court is not obligated to provide you with these copies. The judge is obligated to follow the law. If this were something that he legally were obligated to do, you would have received a copy, but the court is not legally obligated to just print on demand and send you things just because you can't go get them. This document is a must for this hearing and only fair that I have also. Please send at your earliest opportunity or refer me to where I can obtain immediately. I've been asking for this for over 3 years. I want the same advantage in having this document and what the entire hearing is about. Thank you for the opportunity, Sarah Boone. Of course, she doesn't know they've canceled the hearing, which is why he doesn't need to respond to this in any way. But also, the court is not obligated to provide you with copies of things. You have to formally request them, pay for them, or somehow get access to them online, or get your brother or someone outside to access them, print them out, and mail them to you. Obviously, no one wants to do that for you because, well, you talk to them the way you talk to them. So we've reviewed the order they set for the virtual hearing, the motion Brian's attorney filed to continue the contempt hearing, the order granting the continuance of the hearing, and then the letter from Sarah thanking the judge for scheduling the hearing, which was awkward. Now we're going to have a notice of appearance of counsel for Sarah by Frank J. Bankowitz. So let's see how long that lasts. This was filed by Bankowitz on May 2nd, 2023. Notice of appearance comes now Frank J. Bankowitz, and hereby files his appearance as attorney of record for the respondent, former wife Sarah K. Boone, in the above captioned matter, and further requests that copies of all future pleadings, correspondence, and all communication on behalf of the respondent, former wife Sarah K. Boone, be sent directly to the undersigned counsel. And there's a certificate of service that a true and correct copy has been furnished to Joshua Martell, attorney for petitioner, and he lists his contact information. This was filed June 14th, 2023, and it is a satisfaction of judgment and certificate of delinquency. And this says that I certify that pursuant to the Florida statutes, I'm the local depository for court-ordered support payments in Orange County, and that a certificate of delinquency recorded in official records of the public records of Orange County, Florida, was entered against Brian C. Boone, the respondent who was delinquent in court-ordered support payments. So this is a letter saying that he was delinquent in court-ordered support payments. This is why I think they had roughly $4,000 in an account at the Orange County courthouse. It says the certificate of delinquency is a final judgment by operation of law. I further certify that delinquent support, together with all interest and assessed costs and fees, have been fully paid, and the final judgment of delinquency is hereby satisfied. So this is why Brian was continuing to put money in the child support account, because the court order is still active, even though he had filed for the modification. And if the support is not paid, there can be consequences. So he was keeping that current, that $100 a month child support current that he was having to pay through the Orange County courthouse into an account, and they could not dispense it to her, as we saw in those letters earlier in 2022. Because she didn't update her address with the account, and also her account was closed, so they could not dispense the funds to her. So that is why there is that roughly $4,000 being held in the Orange County courthouse that Brian is requesting be returned to him, since Sarah does not have any child support expenses. But he was legally obligated to put it in the account until the order was changed, so he didn't have things like his driver's license suspended. This was written by Sarah June 28th, 2023, and for some reason it wasn't filed until 8/1/2023. She is big mad in this letter, and she writes a lot, so just buckle up and get prepared. Whomever actually reads this and cares, if anyone, that's how she started this out. Whomever actually reads and cares, if anyone. Why are you continuing to enable former husband, petitioner Brian C. Boone to break the law and lie to the court, never being reprimanded or even asked about anything? Judge in any case is supposed to be a teacher and guardian of the law, which includes all rights to all citizens of the United States, no matter being rich, poor, smart, stupid, with or without an attorney. Everyone, including me, who has avidly and diligently fought hard still and tried everything I can to be treated fairly, properly, correctly. In my case, and from experience still, am not or have been ongoing and repeatedly. I do not want to be lied to or laughed at by anyone. Do you think George liked being laughed at? In the suitcase? The judge and court are allowing former husband to do as he pleases. He has money, and here's the root of what she cares about. I rot in jail in preparation for prison. I have nothing. Keep losing. Okay. To make the court aware, former husband and his attorney lied to everyone and myself during the trial for his temporary petition to relocate on 3/29/23, where he was granted permission to take my minor son away temporarily and move well beyond the 50-mile radius to. During this trial, when asked by his attorney, former husband stated that he would be renting a home temporarily, which was understood and granted as being temporary until my case currently is settled and complete, which it still is not. They are buying and moving permanently. I was told by my son, their house is under contract and in the process of undergoing inspections to be completed next week. This is not temporary. How is he allowed to keep lying? Over. This is not a note to someone in your 6th grade class. Also, homes that are bought can also be sold. When someone buys a home, it's permanent. He tells me everything is going according to his plan and waiting for me to be found guilty. Like the bad guy in a superhero movie, just sitting there telling you the whole plan. No. He calls me a M-word. He doesn't care in the least what will happen when everything changes. What will my son think? No one knows the future, and how dare anyone assume they can. Well, you assume you can when you're constantly talking about getting out and you're temporarily there. You are assuming you know the future. How can you allow former husband to keep lying to the court? He is held accountable for nothing. I haven't even processed the fact that they were even allowed to move before anything has even happened in my case, if it even will. And after I was told by the judge, nothing will, because you can't have a trial before a trial. That's a lie. It's already happened once without any warning, unfairly and deceptively. Judge Deen, what happened to my constitutional rights you stated he was and still is violating during the one and only status hearing there's been in this case, and in which I keep trying to set another for it to just be canceled and me laughed at by everyone. My rights are being violated and approved by you. Wow. When is former husband ever going to be held responsible for any of his innumerable lies? I don't know. When are you going to be held responsible for locking someone in a suitcase and mocking them while they begged for their life? Not paying alimony, moving temporarily, etc., etc., etc. I keep being lied to by everyone because I am incarcerated and have nothing. Take, like you took a life. This is not a justice system in any way on any level. That's right, because you committed a crime and you were able to drag it out ongoing, however many years this is at this point, 3 at least. He lies, gets everything and approved. I tell the truth. That's debatable. Get nothing. You're going to get life. And why shouldn't he get everything? He didn't commit a crime. I can't even get a copy of my still active dissolution of marriage because the court is not required to provide you copies of agreement to know what exactly I'm owed lawfully by former husband, because now I'm told I have to pay per page per the marriage department I've written to 3 times and no one will supply otherwise. Also, I cannot have an outside source print and mail from being non-public. Well, you can. You just have to register for an account like I did. And then you can have these lovely letters. Please grant my motion for a case management hearing and without cancellation, so Brian C. Boone, former husband petitioner, can lie directly to the court again when asked why he's now buying a house and why he's still not paying alimony after he has been ordered by the judge in court to twice, along with all my other undeniable concerns I've been trying to have addressed for almost 4 years. Well, he's a free person, so he's allowed to rent or buy. And I don't think the court will care as long as he's putting a roof over your son's head, and neither should you. This court is allowing former husband to be in contempt and to continue being in contempt while I am and have been robbed of everything I need, want, and should have by law. Hopefully, also this motion for case management, if granted, will be recorded correctly in the minutes or whatever new order may be granted to former husband, unlike the motion for temporary relocation with its numerous clerical errors and document defining mistakes. Apparently, Judge Deen, you don't read those either and should. Whoa. She is like uncalculated, unhinged in this letter. She's accusing the judge of not even reading his own order that he wrote and filed with the court, that it's full of errors. There's a lot of grammatical errors in this, but, we're not going to have our 3-point back, are we? Still waiting to see what justice is. Peons count to I have rights, Sarah K. Boone. So now she's a peon. And then this is the actual motion after her rant. Motion for case management hearing comes now. Sarah K. Boone, respondent, submits her request to the court for a motion to set case management hearing to be scheduled at the court's earliest opportunity for further explanation, clarification, and resolution of the undeniable concerns still pending. You don't need these adjectives in a court filing. Remove non-public status online to view print my documents. No, they're not going to remove the non-public status of any family court domestic issue, especially when a minor child is involved, because they're protecting the rights of the minor child. It has nothing to do with your rights. Other people have rights that supersede yours. And in this situation, they're protecting the rights of your son to privacy, which you keep violating. So that she wants them to remove the non-public status online so she can view and print her documents. If unable, please explain why. Well, I think I just did that. The non-public status makes it impossible to utilize any contents I need from the website since no one will provide for me and cannot obtain anywhere else. Have former husband Brian C. Boone explain reasons for lying to the court by regarding buying a home when stated under oath he would be renting and was part of the granting of his temporary petition to relocate. Please supply a rightful copy of my still active dissolution of marriage. Now, didn't you just say you have been told 3 times why they cannot provide you with the copy? And you're asking again. 4, have former husband Brian C. Boone explain reasons for lying to the court about paying alimony to Sarah K. Boone and not abiding by the still active dissolution of marriage or direct orders by Judge Deen. He delegates what I can and cannot purchase with my allowed alimony funds, also telling me to stop relying on him and being annoying. No, that is not quote unquote, ma'am. You are 100% being annoying. Begging all the time. Then pay my monthly owed lawful alimony, so I can get another account to be deposited in after letting my 30-year bank account close due to non-payment of alimony, so I can stop calling every week or every other day for commissary funds, which I have had to do ongoing for years, to be added to my jail account and not have to talk to former husband unless regarding my son. He makes me have to call and be annoying for everything, for nothing. Just pay like you are supposed to be and make everyone's life easier and less stressful. I do not want to be in regular unnecessary contact with him unless necessary. So you don't want to be in unnecessary contact unless that unnecessary contact is necessary. Okay. I cannot see my son all the way in this other place, go anywhere to get my life back in order when, not if, the time comes. I have been forced by former husband and the court to lose my car from non-payment of owed alimony and his permissible contempt. Explain how former husband Brian C. Boone can purchase numerous frivolous items such as a bidet, $1,200, plus or minus virtual reality video games, controls, headgear, plus or minus $1,000. Where are you coming up with these estimates? Alcoholic beverages, rum 2 to 3 times a week, pack, in parentheses S, of cigarette every day, eat out, order in food every day, but he cannot or will not provide my alimony payment so I can purchase what I need. I never have what I need and still do not. 7, solidify verbally and in writing why the court is permitting former husband Brian C. Boone to continue being in contempt in not paying any alimony when it is not stipulated or included anywhere in the still active dissolution of marriage regarding incarceration for either party. This is my only source of income for everything. Have former husband Brian C. Boone explain why he lies about ordering anything for me when he does not and says he did and does. I have received reprimands from Of course you did. From arguing with vendors and officers over the phantom orders that were never placed by him. Why? Is it funny? Well, yeah. For almost 4 years, I cannot purchase what I need or want because he withholds alimony. And there's a little star there. I can have someone else order whatever for me whenever and know it's done and on the way. No lies, no problem, no abuse. Former husband just needs to pay so I can without him. Again, he makes me rely on him just to lie and abuse and laugh at. Have former husband Brian C. Boone explain why he lies about him sending anything from my son. A. February 14th, 2023, Valentine's Day card. Former husband collaborated with my 12-year-old son to lie to me about making me a card. Both said they went to the craft store and bought supplies. My gift to son, had son sit down Sunday afternoon and make, then mailed the completed card the next day. I was told my son wrote me a letter and drew something nice for me. I was really going to like it. It was all a lie. Well, maybe the jail just didn't allow it. They never went or did any of it. What an awful, unnecessary lie for no reason. Nonetheless, former husband had my son part of the awful lie. How disgusting and hurtful. No card ever. May 14th, 2023, Mother's Day card. Former husband has told me 3 times now my son has mailed my created card. Nothing has come. Another despicable lie. Why so hurtful and son included? Present date, pictures. Lies every time he has sent them over and over and over with nothing received. The pictures are ordered from a professional website. Other inmates receive pictures regularly, weekly. I even had the solution to have him send anything, everything in my friend's name. Nothing ever, and keeps lying. This is abuse, mental and emotional. Torture. You knew what was really torture is that snuff film you made. Making someone go through mental, emotional, and physical abuse. Pictures 2 of my now deceased dogs I need for a visit, explaining the importance to former husband, waiting ongoing now for 2 months with nothing, and I need these. I've already been unprepared for 1 attempted meeting, which was rescheduled from not having the pictures and still waiting to receive in time for the next. I need these pictures. This is important. And what example is former husband Brian C. Boone setting for my son? By all his lies all the time. It's okay to treat women this way. And what example did you set? By the way you treated your boyfriend. What does that say to your son? What does that say to him about how women should treat men? 3-point back. That it's okay to treat women this way, nonetheless, his mother. My son is constantly conflicted with how he's supposed to treat me and act towards me because of what has been said to him about me and my family, and is afraid Dad will be mad because he's not being mean enough to me. Ma'am, no, that's not why he's acting like that. My son continuously puts me on mute. Also, that I don't hear what Dad is saying while on the phone with me. My son is a different person, not around him. Have former husband Brian C. Boone explain to the court why and how he believes it is right and appropriate to call me a word and keep slandering me, speaking ill of my son, laughing at and mocking. Have former husband Brian C. Boone explain why he never communicates anything to me, especially regarding my son, which will avoid any additional confusion and hurt, and why he feels it appropriate to decide I don't matter in my son's life. Nothing I say or do is important, and only former husband's decisions or reasons are the best. I am not convicted and still have all my rights intact. No, because you can't leave. Can't have delicious delight. All of us on the outside can do all of that. 12. Former husband Brian C. Boone explained why he's not my attorney, since he thinks and assumes he knows all there is regarding my case more than me. He thinks and assumes he knows all there is regarding being incarcerated more than me. Why is that a flex? He thinks and assumes he knows how it all works. The letters I write, how much commissary costs, and the constant price raises, the regularity and costs of my medical expenses that I am charged every day to be here in OCCD, rules, regulations, etc. He knows nothing about anything. I tell him I have printed documents showing all costs incurred since being incarcerated, so he understands. And why have these never been submitted into evidence? You supposedly have been preparing for 2 years, showing all costs incurred since being incarcerated, so he understands, and in which I have prepared as my evidence also have recorded phone calls. Where are these recorded phone calls? We want them. For my contempt hearing, which has been postponed, allowing former husband to continue contempt. Stop being so simple-minded regarding my case. Stop being another ignorant, oh, ma'am, I'm not reading that, follower of all the other ignorant followers. Shh, stop. She just said shush, exclamation point. I think she's trying to refer that to her husband, but it just, I don't know. The judge could think that's directed at him. Undeniable orders by Judge Michael Deen to Brian C. Boone. Now, see, they are not undeniable, and we've already looked at them, and he said there would not be any action taken. By Judge Michael Deen to Brian C. Boone, former husband petitioner, have not been upheld or abided by and are in violation as ordered. I've never seen that order. They continue to multiply in severity and duration of time and destruction, being unlawful, extremely inappropriate, and altogether wrong. Former husband is in contempt, stealing and lying to the court. Judge, myself, responded. We've never seen these orders. She keeps complaining about not having the copies of things and can't see the family court docket. So what is she basing this off of? Something she thinks she remembers someone saying? Yeah, I wouldn't trust your memory, Sarah. Wherefore, Sarah K. Boone, respondent, respectfully requests. I don't think you did that. I don't think you requested respectfully that this honorable court please grant this motion and enter its order to set and keep a case management hearing regarding all undeniable aforementioned legitimate overdue concerns and owed explanations regarding and from former husband and petitioner Brian C. Boone. Sarah K. Boone, respondent, has attempted private resolution. No, you haven't. Cooperation and discussion with petitioner numerous times over the past almost 4 years while incarcerated, being unsuccessful in every aspect due to the fact former husband Brian C. Boone has the understanding from the court his behavior, degrading, inappropriate comments, and ongoing lies are approved and able to continue. Clarification, remedy, and solidification are requested for all undeniable concerns for all parties included in this case to avoid further confusion, difficulty, lies, and abuse going forward, especially for respondent Sarah K. Boone from petitioner Brian C. Boone. Thank you, Sarah K. Boone, respondent. Now that was, I think, maybe the most unhinged one yet. What do you guys think? This is a notice of delinquency that was filed 8/3/23. It was sent to both Sarah and Brian. It just basically states that he is delinquent in child support payments in the amount of $200. Now we know that he was ordered to pay $100 a month, so that means he has gotten 2 months behind. So failure to make the payment plus all amounts that become due plus costs of $32.55 will result in a judgment being entered and interest will accrue. This is why Brian had to continue to put the child support in that escrow account with the clerk of court until the judge orders, hopefully very soon this week, on the modification. This is the same notice. It was filed 8/28 and it was returned unclaimed and unable to forward. I'm not sure whose copy it was, but they were not able to get it, but it's just the same notice. This was filed 8/24/2023, and it just basically says that the total balance due was $200 and statutory interest was accruing, but it basically says that it is another judgment certificate of delinquency. That is the second notice they sent out from the same date. This one is dated August 23rd. Let's take a look at our timeline. So we saw the notice of appearance from Bankowitz. We saw the satisfaction of judgment delinquency from the child support letter. We saw Sarah's letter that was completely unhinged. We saw another notice of delinquency and then the return mail notice of delinquency. Now we're going to take a look at this motion to withdraw from Mr. Bankowitz. So he lasted from May 2nd to September 20th before he filed a motion to withdraw. This is the motion to withdraw as counsel. It was filed 9/20/2023 from Frank Bankowitz. Comes now Frank J. Bankowitz, Esquire, counsel for the defendant in the above style cause, and hereby requests that this court enter an order permitting court-appointed counsel to withdraw from this case and from further representation of defendant. In support of such motion, the undersigned states to the court as follows. 1. On or about July 11th, 2022, the undersigned was court appointed to represent Sarah Boone relative to Orange County Circuit Criminal Case Number, blah, blah, wherein she is charged by information with second degree M. 2. On or about May 2nd, 2023, undersigned filed his notice of appearance in the above style cause. This was done on a pro bono basis. 3. On August 22nd, 2023, the undersigned filed a motion to withdraw in the aforementioned circuit criminal case. Stated in said motion were numerous reasons that irreconcilable differences existed between the undersigned and Sarah Boone. Exhibit A. 4. On September 8th, 2023, the Honorable Wayne Wooten granted the motion to withdraw and undersigned was relieved of further representation. 5. As such, the undersigned will be unable to effectively and properly continue representing Sarah Boone relative to the above style case. Wherefore, undersigned counsel respectfully requests this honorable court enter an order granting this motion to withdraw as counsel for the above named respondent wife. And he has the certificate of service. And here we have Exhibit A, which is the motion to withdraw as counsel filed on 8/22/2023 in the criminal case. Comes now Frank J. Bankowitz, Esquire, counsel for the defendant in the above style cause, and hereby requests that this court enter an order permitting court-appointed counsel to withdraw from this case and from further representation of defendant. In support of such motion, the undersigned states to the court as follows. 1. On or about July 11th, 2022, the undersigned was court-appointed to represent the defendant in the above style cause. 2. Due to irreconcilable differences which have arisen between the undersigned and his client, the undersigned will be unable to effectively and properly continue representing the defendant herein. 3. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dictate his or her time solely to Miss Boone's case. 4. The undersigned has been in M trials over the past 60 days and is presently defending a capital M case in Lake County, Florida, which absorbs all of his time, including weekends. 5. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. Wherefore, undersigned counsel respectfully requests this honorable court enter an order granting this motion to withdraw as counsel for the above named defendant. And certificate of service for that. All right, so that was the motion. And then on the 28th, the judge sent out a notice of a hearing scheduled for 10/6 at 10:30 and a transport order to send Sarah to court for the hearing. But then on 10/6, they canceled the hearing scheduled for 10/6. So, you know that then we got a letter from Sarah. So we'll look at that letter. I'm going to skip these little notices because they're just pretty standard. And then after the letter, they schedule a hearing on 10/16 at 10 a.m. and another transport order. And then Brian files a motion just to appear by phone so he doesn't have to drive in. Then we'll just look at the order. So I'm not going to show these notices on 10/10. We'll just look at Sarah's letter and then the order from the judge and the court minutes. Here it did order granting the motion to appear by phone after the actual hearing. And then we'll be done with 2023. This was written September 5th, but filed October 6th, 2023, which is the same date they had scheduled and also canceled the case status hearing. So Sarah wrote this motion to read letter from respondent and schedule case management hearing. Judge Michael Deen, in all my attempts, 16 plus, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active abuse from former husband Brian C. Boone. Nothing has been improved, made better, corrected, relieved in any way for myself, the respondent, from former husband, the court, or judge. I have tried everything except be patient and wait for the outcome of your trial. I have made innumerable requests. Well, you just numbered them, 16. Here's the number right here. Sent many letters asking for aid from all with no success or assistance, listening or care by anyone other than myself trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. Who's bitter? Who's angry? Please see list of my letters sent to you. Like they have it on file. Sent to you in court per the Records Management Division of the Clerk of Courts when for the third time tried getting a copy of my active dissolution of marriage agreement I cannot have because they are wanting payment in order to receive, and I am in jail. You need a footnote here that says, because I locked my boyfriend in a suitcase. I also have no bank account. Yes, we know. After the one I had was closed after having for 30 years due to non-payment of alimony from former husband and stated in prior letters. Yes, you stated it in prior letters. Please shut up about that. Here's a list of all the dates of letters she wrote because she's very proud of this and very frustrated that she has not gotten her way yet after explaining and they still don't understand. It is appalling how uninterested, uncaring, and nonchalant you and the justice system are about my side in any of this, and will not listen without the right paperwork and attorney, knowing I am actively being taken advantage of and wrongfully mistreated by former husband Brian C. Boone. You have continuously enabled him and given him a self-appointed right and understanding to keep doing, saying, and taking everything wrongfully and illegally from me, including and especially the love and respect from my son. It is not okay. No one can take love and respect from you, from someone. Like they have to withdraw it themselves. You're a K word. That's why I'm not doing anything, former husband said in front of son on phone. You are not important to anyone, former husband, numerous dates. You are not priority, former husband, numerous dates. And he's right. You are not his priority. He's solely responsible for your son. That's his priority. Dad says you're annoying and beg all the time. Son told me after asking him, oh, look what she's admitting right here. Told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. You called them daily for 13 weeks? to ask about a book. I'm sure they have a library. Check out one of those books. Read something else. Yeah, that is annoying. And that is begging all the time, every day. So that is an accurate statement. That is not abuse. You are the one being abusive. I lie to you because I can. Dad does all the time, son. You make no difference in our lives. Former husband, numerous dates, 9/4/23, recent. That's okay with you and acceptable, Judge Deen? Is that what you are giving him permission for and to keep doing in front of my son? Sarah, do you know what you did? Are you even aware of it? Why won't you stop any of his abuse, verbal, mental, and emotional? It's not abuse because you couldn't eat a hot meal or read a certain book. It's called jail. And you're in jail because of your actions and your abuse of another human being. So, why won't you stop any of his abuse, verbal, mental, emotional? Why aren't you as my judge, not anyone? No, he's the judge over the case that involves you, your ex-husband, and your son. Why aren't you as my judge doing anything to hear, understand both sides? He explained to you. We'll read it again in the next court minutes. The next court motion or order. What else needs to be done to me by former husband in order for you to help me? What else can I do I have not done already for any relief on my side? I bet George was thinking that. What else can I do to get relief on my side of the suitcase? While you laughed at him. Stop enabling. Judicially, you must know this is wrong in how I am being treated. I am told every time when trying to reduce any anguish or mistreatment from former husband and cooperate trying to help, the judge doesn't care what you write. My son now says the same when I correct him on how he's being mean and rude to me. He's never going to do anything for you until your trial is over, and even then it will still all be in my favor. My other document is ready to go so I can take the rest. I have an attorney. You deserve nothing. You mean nothing. I agree with this. You deserve nothing. Then former husband gets his precious attorney. You just had one withdraw. And why was that? You had one. To file another answer denying allegations because I'm telling the truth all the time about his awful lies and I am right. What? Judge Deen, so I have to continue taking former husband's abuse, neglect, unlawful actions, cruel comments, and hate until my trial, if and when it happens. Well, you could just stop calling and talking to him and begging him. You already know how he feels about it, that he's not going to send you anything. So stop calling and then you won't have to deal with the quote unquote abuse. You misplaced your quotation marks. They should be here. Unlawful actions, cruel comments, and hate until my trial, if and when it happens, however long that will be. Now considering my attorney has withdrawn, whose fault is that, from my case, and no date of trial is known or will be for an undetermined amount of time. And the judge told you that meant a delay of case, and you agreed in open court and on camera. How much more hate and disrespect will former husband encourage my son to keep lying and overall being mean to me, his mother? Here she goes again. Just be nice to me. Former husband is teaching and reflecting a terrible example of how women can and should be treated, nonetheless, the mother of his child. This is egregious and wrong. Please read my prior motion for case management hearing I sent 6/28/23 with no response to date. I am requesting again, please to schedule. It is fair, and there are too many topics to be discussed, including my attorney to write, and I only have one pen. Necessary, lawful, active, important topics. What is the certified notice of delinquent support filed 8/3/23? You got a copy in the Orange County. Maybe hers was the one that got returned. The jail didn't accept it. Please grant my motions and schedule my imperative overdue owed meeting. Yes, you think you are owed everything. Everyone needs and must have the same understanding now and future. It is fair. What else can I do? What's left except for begging, which former husband says I do all the time? What am I doing wrong in order to be treated rightfully, properly, ethically correct in order to finally receive your judicial assistance? How I am and have been and will be treated by former husband Brian C. Boone is unfair, malicious, and wrong and should not be in any way allowed to continue. Stop. Please see, please listen, please help. Judge Deen, what was the reason for your comment made in your courtroom about former husband violating my constitutional rights? If you're not going to help or uphold said rights and lawfully allow me to use, what's the point? Why do I even have? You know I do in order for you to remark and see they are being violated on 9/19/22. We did not see that in any court minutes, though. Please schedule. It is my right. It is fair. Sincerely, Sarah Boone. Please send a copy of this letter so I know it was received and will serve as my receipt. And then she includes this letter from Legal Aid, dated June 29th, 2023. And she wrote, my dissolution of marriage is still active until 2025. Family Law Matters. Dear Ms. Boone, we have reviewed your letter requesting legal assistance. This letter is to inform you that the Legal Aid Society of the Orange County Bar Association, Inc. will not be able to assist you regarding family law matters. Our office receives hundreds of requests each month for free legal assistance. While we would like to help as many applicants as possible, due to limited staff and other resources, we are unable to assist everyone who contacts us. As a result, we have established case acceptance priorities to address the most pressing needs of our client community, and thus, we do not accept matters that involve alimony or custody time sharing on behalf of a parent who does not have the child residing with them for at least 50% of the time. I wonder why they don't accept that as a general rule, Sarah. Our consideration of your case was limited, and our decision not to provide legal representation to you does not mean that you do not have a good case or defense. You should be aware that the passage of time might prevent you from pursuing your claim or defense. Obviously, they put this on every letter they send out. This is just a canned statement, but she underlined that. We are not aware of any free legal resources to assist you. We suggest you contact a private attorney, which you already ran one off, of your choice, or the attorney referral service. And they list the contact information for the referral service. And if you would like to obtain the services of an attorney to talk to, the attorney will charge you an hourly rate. Sincerely, Legal Aid. These are the family court minutes from the hearing on October 16th, 2023. Brian and Sarah and Frank Bankowitz and Joshua Martell were all present. Basically, it just says the court ruling is that the court will take no action on the case management conference. The motion to withdraw is granted, and Mr. Bankowitz will prepare the order. Court recessed at 10:21, and they started at 10:03, just about 15 minutes. This is the judge's order following the case management conference on 10/17/2023. This cause, having come before this court for case management conference on October 16th, 2023, and the court, having heard from all parties present, finds and orders as follows. Both parties appeared for the case management conference, which included a motion to withdraw by the respondent's counsel, Frank Bankowitz. 2, there were no objections to withdrawal of respondent's counsel. 3, Frank Bankowitz is hereby removed as counsel for the respondent. 4, counsel shall provide a more formal proposed order for this removal to be signed by the court within 10 days. 5, the case management conference discussed the status of the case, including the petitioner's request for a reduction or elimination of alimony and for relocation. The respondent is currently incarcerated in the Orange County Jail, pending trial on a charge of second-degree M. 7, the court cannot hear the respondent's motion for contempt regarding unpaid alimony until after a final hearing is held in the respondent's petition for reduction or elimination of alimony. See Rosenblum v. Rosenblum, which they have provided her previously. And it says it reversed a trial court's contempt order because it was issued before the modification action was heard. So they have to follow the process. 8, the respondent expressed frustration, that is an understatement, I'm sure, at not having matters heard and not being adequately informed about her case. 9, the court explained that the family case is on hold pending the outcome of the respondent's criminal case. So stop writing us because it's on hold pending the outcome of your other case. 10. The court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case, that circumstances are clearer. So they're not using a crystal ball, Sarah, like you keep complaining about everyone using. 11. The respondent was informed that she may opt for a final hearing on the petitioner's petition for alimony reduction elimination and her own contempt motion, but that the court would have to consider her current status of incarceration when making determinations. 12. The respondent was advised to ensure that any motions filed conform to the Florida Family Rules of Procedure and the Florida Rules of General Practice and Judicial Administration. This includes utilizing proper citations, titles, and certificates of service. Ordered in Orlando on the 16th day of October, Michael Deen, and certificate of service. And this is the order on motion to withdraw as counsel that Bankowitz had to write. It was filed 11/17/23. It did say he had to do it within 10 days, but it looks like he took about 30 days. This cause having come to be heard upon the motion of Frank J. Bankowitz, Esquire, to withdraw from further representation of Sarah Boone, and the court having reviewed the court file, read the motion to withdraw, conducted a status hearing on October 16th, 2023, at which counsel for the petitioner husband had no objection, respondent wife Sarah Boone had no objection, and having been fully advised in the premises, it is hereby ordered and adjudged that the motion to withdraw is hereby granted, and Frank J. Bankowitz, Esquire, is hereby relieved of further representation of Sarah Boone and possibly a major migraine relative to the Bev-style matter. All further correspondence shall be directed to Sarah Boone in her F dorm at the Orlando County Jail. Ordered and adjudged, done and ordered, Michael Deen, and certificate of service. Okay, so that was pretty much everything of note. We went over the orders following the case management conference, order for withdrawal of counsel, that was granted. Now we are in 2024. There are only 2 dates for 2024 that we'll look at. Sarah tries to write some motions. The judge is not hearing it. Then she writes another request, and then we have some action in 2025 that will begin. Of course, I will be checking the docket as much as my schedule allows tomorrow and throughout the week to see if her final closing argument was posted to the docket or if the judge just went ahead and ordered without it, since it's been over a week since it was due. So we'll see what happens with that this week. So in the meantime, thank you so much for watching, and I will see you all in the comments.